The constitutional law question from July of 1994 is another difficult con law question. As we get into it, we'll see that it actually sets up in a relatively simple way, and it is a comparatively easy answer to write. But issue spotting and organization are somewhat tricky. Take a look at the call of the question. How should the court rule on the claims of Betty and Marie? Discuss. Well, that doesn't give us a great deal to go on. It suggests perhaps a civil remedies question, where Betty and Marie will be suing everybody else in the fact pattern for claims arising out of torts or contracts or real property. But a quick glance to the preceding paragraph indicates that constitutional law is very much at issue. So let's go to the top of the question and review the facts quickly. Ricks County is a rural, sparsely populated county in State X. There have never been enough female prisoners to make it economically feasible to have separate facilities for them in the Ricks County Jail, which is located in Hickory. Consequently, Ricks County has always placed its female prisoners in the Rock County Jail, some 30 miles from Hickory, under a contractual per diem relationship with Rock County. Well, we look at this paragraph and we ask about Betty and Marie. We wonder, are these two inmates? Are they being discriminated against vis-a-vis male inmates? Well, read on. In paragraph 2, we meet Betty, and we get facts about Betty. She's just moved to Hickory from the state capital. She's worked already as a prison guard in State X at the state level. She has applied for a position as a deputy jailer in Ricks County. And then they tell us her vital statistics. She's 34, 5'5", 145. And she's got a junior college degree. Okay, well, she appears to be qualified to work as a corrections facility officer, or a guard as we might call them. In paragraph 3, we learn about our other plaintiff in the call of the question, Marie. She's an ex-Marine, just got out of the service, and she's a high school graduate. She also wants to be a deputy jailer. She was a military police officer for 2 years in the Marine Corps. She's 22, 5'7", and 155. Well, why do you think it is that they would tell us these vital statistics about these two women? I can guarantee it is not because they want you to be well informed. It's because, obviously, we're going to be expected to compare these vital statistics and to see whether or not they have a legal impact. Move on to paragraph 4. Now we meet one of the defendants, Dan, the Ricks County Sheriff. He says he's not going to hire either of these females because of their gender. Okay, now we know for sure that both women are going to be raising equal protection claims based on gender. And we know that gender gives rise to an intermediate level of scrutiny. Look at Dan's justifications. He says that having women inside the county jail would create unmanageable security problems, and he states some reasons. 1, women aren't strong enough, and secondly, there's a danger to the guards from sexual assaults by male prisoners. And then, finally, he makes one more argument, which is having a woman jailer would infringe on privacy rights of male inmates who have to use toilet and shower facilities in full view of the jailers. Well, you know what? I don't think we're too concerned about the privacy of inmates. They lose their privacy when they surrender their freedom. And then, the last argument of Dan, finally, it actually may have some merit. Dan claims that Betty did not meet the minimum height and weight requirements for deputy jailers under State X law, 5'6", 150. And these requirements always have been enforced. Well, it doesn't look to me as if those requirements are designed to weed out women. Rather, it's designed to weed out short people. And I hear the Randy Newman song playing in my head. Okay, in the next paragraph, we find that Dan agrees that both women meet the age and educational requirements. They're at least 20 years old and they have a high school diploma or its equivalent. Both Betty and Marie have letters from their supervisors from previous employment stating that they are competent, reliable, good to average, and no job performance problems. So clearly these women are qualified for this job. The only question is whether or not they should be entitled to obtain employment. So look at the last paragraph. It kind of sets up the call of the question. Betty and Marie each have filed a complaint in federal district court in State X against Ricks County and Dan. The complaints seek injunctive relief requiring the defendants to approve plaintiffs' job applications and to employ them as deputy jailers under rights guaranteed by the U.S. Constitution. Given the similarity and major issues, the actions have been consolidated. Okay, well, that's a not too subtle hint about how we ought to organize our answer. We should not have big, elaborate, separate sections about each of these claimants. Although, as you see, I do distinguish between the two of them, and I have a separate section about Betty. So, turn and let's have a look at my outline of issues for a minute. You'll see right away how I set it up. Although this fact pattern does not explicitly give us the constitutional theories, certainly this is an equal protection problem more than anything else. So have a look at the framework of my analysis. We've got private plaintiffs, and that means we have to talk about standing and state action, both of which I cover in the outline. Next, we consider the 14th Amendment and gender discrimination, and then look at how I use Dan's justifications as an organizing principle for a separate section. 1D1 through 3 gives me a chance carefully to focus on the rationale offered by our key defendant. In the end, I conclude in favor of Marie. Now, I can tell what some of you are thinking because you're having a question arise that I have heard many times before. The fact pattern itself makes reference to injunctive relief. Isn't it appropriate to have a separate section all about equity in this answer? And my answer to that question is no. I don't have a separate section about remedies because I don't think this is a remedies problem. This is a con law question, and so I devote my energies to answering the con law issues. Certainly a paragraph about injunctive relief is not out of place. But if you take the time to do a full injunctive relief analysis, I just don't think you've got enough time to do justice to the real con law issues. So now let's take a look at Betty in my outline. I indicate that her failure to meet the state X height requirement hasn't got anything to do with her gender. Here again, Betty has to rely on the 14th Amendment, but we're going to apply the rational basis standard, and it seems to me not irrational to require that our guards in jails are big enough to handle the job. I think it meets the rational basis standard. So that sets up our answer. Once that work is done, we can see that the answer itself actually is fairly easy to write. Our outlining, once again, turns our answer into a series of short answers. So let's have a look at the answer. Take a look at page 1. We've got a discussion about Betty and Marie's equal protection claims. You'll see that I start off with standing and state action. Also, you can see I throw in a little one-liner about the 11th Amendment. As you'll see as you review these con law questions, the 11th Amendment often is a handy issue to throw in, kind of a kitchen sink approach. I don't dwell on it, but I think you'll agree that it isn't out of place in this analysis. Next, I focus on the 14th Amendment and gender discrimination. Notice how I actually lead off with a little bit of law. I refer to intermediate scrutiny, and I state the standard of review. We've got to show a substantial relationship to an important government interest in order to justify the discrimination. And I place the burden on the defense. Next, I focus explicitly on the justifications of Dan for not hiring either Betty or Marie. And take a look at my analysis here. I won't read it to you. Have a minute and read it to yourself. But I think this is an example of clear, concise, factual analysis. Here, I really take my time. I cover all of the details, and I explain my analysis as clearly as I can. My conclusion, Marie wins, because the equal protection claim that she raises is one that I don't think that the state really can reply to with any legal force. But Betty's situation is different. Notice that Betty is too small for the job, not too female. So have a look at the analysis. Again, Betty has to rely on the 14th Amendment, and again, equal protection. But then, in Part 2B, I indicate that a very different standard of review is going to apply. She is not claiming a discrimination here based on being female. She's claiming a discrimination based on her height and weight, and rational basis is going to apply to that line item of the statute. And take a look at my analysis. Weight and height have never been named suspect classes, and I follow through to the conclusion. Ricks County always has followed these requirements, and Betty's challenges should fail based on equal protection. Now, notice in Part 3, I actually do spend a little bit of time on injunctive relief. But notice, I don't let it play out across a whole page or two, because, realistically, I just don't think there's time. In the end, I conclude that Marie wins. She's going to get the injunctive relief that she's after.